Hi, this is Curt and welcome to another edition of Fire Law Roundup.
Let's start with the not surprising, but another good holding, which also I'm going to try to stretch beyond this holding, but we're going to start with City of Jacksonville and a federal district court, the lowest level federal court, doesn't mean it's not important, it's just the first of three federal courts, has continued the holdings of two prior cases, one involving the FDNY, which is very well known, the Bay case, but saying that African-American firefighters who have a disease which requires them to, which is better, it's a skin irritation disease, and it's better when they have some growth, is part one, and part two, shaving too close causes severe and painful irritation. And here they sued, saying that it's a discriminatory practice, requiring this to be so close shaven. And, you know, we've seen a couple of these cases, obviously the Bay case, but what the court held, let me start with what the court held and then tell everyone why this happened, I think. So the court has held that, and this is an important standard for this and many other cases on similar or even totally different topics. The court held that when a federal or state, I suppose, regulation, in this case, the federal 1910-134, when the federal regulations prohibit, right, certain conduct or mandate certain conduct, they prohibit beards, they prohibit interference with the seal, and they mandate that you be clean shaven within 24 hours. There would be not even 24 hours of growth. That's what I'll address as the new issue. They said that they held that when a federal regulation requires conduct or prohibits conduct, that compliance with such conduct is not discriminatory. It's a great holding. It's the right holding. Look, I always sympathize, you know, as the case reflects that African Americans are more prone to this skin irritation disease than Caucasians. And so I sympathize, but OSHA has the 1910-134 rule, the clean shaven rule, right? I'm not going to be an interior firefighter right here with my little beard. So I think what is brought on these cases is more adequately reflected in the Bay case, which is that many departments allowed 1 day of growth prior to this and said that kind of stubble didn't interfere with the seal. But 2 or 3 or so years ago, OSHA comes out with a clarifying opinion and says, not anymore. There can't be any growth. In fact, some departments, and this was discussed in the Bay case, some departments require you to shave, you know, 2 or 3 times a day if that's what you need to do. And that was extremely irritating to this condition. You know, look, it'd be irritating to anybody to have to shave, but that memo, I don't know, Curt, if you've ever seen that, but that memo, or it's not mentioned in any case, maybe mentioned the Bay case, the FDNY case, but that caused my phone to ring a lot. And then it was since then when we saw a lot of these cases come back, because the departments are changing their policy to say, okay, now even 1 day of growth is not acceptable. And that's as a result of that OSHA opinion letter. So that's what I think is why we're seeing these. But so that's the holding. But I also want to say, you know, move this to marijuana, right? Where we've seen ADA cases that have said at the federal level, listen, we're not going to allow the authorized or certified use of a THC cannabis product. We're not going to allow that. And you, the employer, can discriminate, right? But can legally prohibit someone from using a THC product, even for a medical condition. Why? Because federal law declares it a controlled one substance. So the specific holding of this case, that compliance with the federal law regulation is not discriminatory, I think we can take to a lot of different cases. So I just thought it was interesting. It's the right holding. And again, I sympathize with everybody, but it's not shocking, right? What was shocking more so was the Bay case, frankly, where it was the Second Circuit reversed the trial court level. So at in the FDNY case, the trial court actually held in favor of the African-American firefighters.
Yeah, but that was a crazy ruling. And I think I don't know if the judge really grasped it. I'm not even sure. He might have even been retired at that point, but he was the chief senior judge. He had been around since the 70s. And I don't think he fully grasped the issues, but because you can't, like, he pointed to the fact that no firefighter has ever been overcome because of the stubble. And yeah, and he used that as, or over a 3 or 4 year period, no firefighter had, as proof that it's safe to do. And that's like saying, well, I've driven a car for 30 years. I've never gotten in an accident, so therefore I don't really need a seatbelt. I mean, right. You can't, you leave it to the federal agencies. But I got 2 points I want to make. One is that the solution to those who are upset with this, okay, and I know there's a lot of people who are upset with this. If you're upset with this, the solution is research. Okay, the solution is NIOSH taking another look at this and seeing if the regulation is indeed valid, if it still is valid. Now, the regulation goes back to the 70s and 80s when the seals that we had were different. But I think that another round of research by NIOSH looking at this may give OSHA the information they need to go to a different standard. So if you're truly concerned, if you think that this close-shaven rule is racist or you believe it discriminates against people with disability, the solution is not to rail against the judge, rail against the law. You need some research. We need to figure it out. And then from there, OSHA can change its standards. So that's really, I think, the logical approach to this. The other issue has to do with a case out of DC from back in the, I think it was the mid 2000s. And our friend there, Dennis Rubin, was the chief at the time. And there was a strategic decision that the firefighters in DC challenged the no beard rule. And there was a strategic decision that I think in hindsight was a blunder, but they made the decision, the lawyers made the decision not to argue about positive pressure SCBA as you need to be clean shaven. Because at the time, it was post 9/11, the firefighters and the police officers in the DC area, beyond that, also even in my community in Providence, the police were given suits and negative pressure masks to keep in their patrol cars in the event that they came upon some sort of a terrorist act or whatever. So at the time in DC, all of the police officers and firefighters had these Tyvek suits and negative pressure masks. The attorneys made a strategic decision that our better argument is to argue that you need to be clean shaven because of the negative pressure mass. And so therefore they conceded the positive pressure issue, believing that they were going to prevail on the negative pressure. And, a couple of questions in on, the hearing, and no one has ever had to use the negative pressure mask in the history of the department. Therefore, it was considered to be like a pretext. And you already conceded the positive pressure aspect. They didn't argue OSHA. And, the case was over. So I know that a lot of people say, well, I thought the DC case said, well, you can't rely on the DC case. Okay, there was some legal strategic errors, I think, that were made there. And the better case, I think the Bay case is a good one. Atlanta's kind of dated, but it's a good one. But the Bay case out of FDNY, and now this one out of Jacksonville, Florida, I think are going to be the ones that really kind of set the pace.
And what I like about this, and you've kind of been alluding to, is, this case focused specifically on, look, it's a federal regulation, end of story, as opposed to saying, is the federal regulation reasonable, right? It doesn't matter. It's a federal regulation. So compliance with the federal regulation, rather than trying to unravel it and find if it works or not while the regulation exists. And of course, you can't say you're being discriminated against when you're complying with the federal mandate. It was the right holding, but I liked the way they worded it. I thought Bay kind of went, and I haven't looked at that case for, a half a year or so, but it kind of went more into the, is it reasonable standard versus here, it's a rag, it's over.
Well, we get into the thing that we talk about this in the FLSA class a lot more, but it's deference, judicial deference to federal regulations. And that in theory, we don't want, for example, I like to go to a metaphor to the airline industry and the FAA. We don't want judges deciding the landing patterns and the takeoff patterns out of an airport like JFK. I mean, that's crazy for a judge to go playing around with regulations that could potentially kill someone. And this is the same thing, that the judge has no expertise in this area. OSHA is the federal agency that has expertise in this area. The judge should not be touching that, not looking at whether or not, I mean, if it's clearly unreasonable or, it's arbitrary, there's no reasonable basis for it. That's one thing. Okay. And then there's a standard for that. But we don't want to see in a given case, given the sympathies that can come up in a given case and all that, we don't want federal judges usurping the authority of agencies that have the expertise to develop these regulations. And I think this is a good case upholding that principle.
Absolutely.